Welcome to the deep dive. We cut through the noise to get to what really matters. And right now, there's this huge constitutional fight brewing in Washington. It could genuinely change, who's actually in charge of the government. We're seeing President Trump in his second term really pushing the boundaries of executive power. He's shaking up agencies, ones we always thought were kind of independent, firing officials who, well, most people thought had job protection. This isn't just shuffling deck chairs. It feels like a real challenge to decades of legal understanding. It's happening right now.
It absolutely is. You called it a sea change, and that's exactly what it feels like. The Supreme Court's already involved, actually. They've issued these stays, basically green-lighting the administration to remove some key people. We're talking about folks at the Merit Systems Protection Board, the MSPB, and the National Labor Relations Board, the NLRB. People like Gwen Wilcox at the NLRB, Kathy Harris at the MSPB. Their cases are literally sitting with the Supreme Court. And this signals a massive rethink of how much power a president has over these independent parts of the government. It challenges this whole system that's built up over, gosh, nearly a century.
Okay, right. Let's try and unpack this. So the big question is, could a president just fire anyone in the executive branch? Really transform how things work? Or are there supposed to be checks, built-in protections? Today, that's our deep dive. This escalating fight, legal and political, over the president's power to remove officials. It could redraw the lines of government power completely.
Exactly. And we'll look at how the Supreme Court's view has, evolved. It started off backing broad presidential power that shifted towards limiting it for these agencies. And now it seems to be swinging back again, empowering presidents. We'll dig into the arguments, for a strong president versus independent agencies and the potential consequences for accountability, for stability, for this whole huge federal bureaucracy we rely on.
Okay, so at the heart of it all, there are really two, pretty different ways of thinking about presidential power and how government should run. On one side, you've got this idea called the unitary executive theory. A lot of conservatives back this. It basically argues for one strong president controlling the entire executive branch, everything closed from the top.
That's the core of it. It goes right back to Article 2 of the Constitution. That phrase, the executive power shall be vested in a president. Proponents say that means all executive power, not just some of it, the whole thing. And then there's the take care clause the president has to take care that the laws be faithfully executed. Well, the argument is, how can the president take care if they can't control the people carrying out the laws? They need that control to do their constitutional job.
Right, and that brings up accountability. That's a big piece of this argument, isn't it? Supporters say, look, the president is the only one elected by everyone in the country. So if agency heads are protected, if they can't be fired easily, then how can you hold the president responsible for what the government does or doesn't do? Chief Justice Roberts even said it in a case, see la law, the buck would stop somewhere else, meaning not with the elected president.
Exactly. And the historical anchor for this view is a really famous Supreme Court case from 1926, Myers v. United States. Chief Justice Taft, who'd actually been president himself, wrote the opinion. He basically said the president has the exclusive power to fire executive officers, period. He looked at the Constitution structure, even what the very first Congress did, and argued, look, without this firing power, the president can't really execute the laws faithfully, can't be held accountable. So for the Trump administration and many conservative legal thinkers, Myers is kind of the gold standard. The correct reading of the Constitution on this, think of it like a CEO, right? They need to be able to pick their team and remove people if they aren't executing the vision. Otherwise, how can they be responsible for the company's results?
Okay, so Myers seems pretty definitive. President has the power. But that wasn't the end of the story, was it? Because for a long time after that, things went in a different direction. We saw lots of agencies being set up specifically to be independent, with leaders who couldn't just be fired. So what was the logic there?
Right, this is the other side of the coin. The argument for agency independence. Congress deliberately set up agencies like the Federal Trade Commission, the FTC, or the NLRB to be, impartial, to have specific expertise. And they wrote laws saying the leaders of these agencies could only be removed for cause. Things like inefficiency, neglect of duty, or malfeasance. Real reasons, not just political disagreement. The idea was to shield these experts from political winds, let them make decisions based on the law and the facts, not who's currently in the White House. The MSPB protects federal workers from unfair treatment. The NLRB oversees labor relations. These aren't abstract things. They affect people's lives directly. Independence was seen as key to their function.
Yeah, it's kind of like tenure for a professor, maybe, or protections for union workers. You need a good reason to be let go. It acts as a check on the president, right? To stop one person getting too much power, maybe becoming, as some critics warned, closer to a king than a president. It's about balancing power.
Exactly. And the legal justification came surprisingly quickly after Myers, just 9 years later, in 1935, with Humphrey's executor v. United States. The court, unanimously this time, said yes, these for-cause protections for FTC commissioners are constitutional. Their reasoning was interesting. They said the FTC wasn't purely executive. It did things that were quasi-legislative, like making detailed rules, almost like Congress, and quasi-judicial, like settling disputes, almost like a court.
Okay, quasi, meaning sort of like.
Sort of like, yes. Not fully legislative or judicial, but having elements of those functions. Because of that mix, the court said the president's removal power wasn't absolute here. And that decision, Humphrey's executor, became the foundation for independence at many, many federal agencies. Later, in 1988, Morrison v. Olson kind of reaffirmed this, focusing on whether the firing restrictions seriously got in the way of the president's duties. Though it's crucial to mention, Justice Scalia wrote a really fiery dissent in Morrison. He argued it messed up the separation of powers and weakened accountability. He was a big proponent of that unitary executive idea.
Okay, so we had Myers saying broad power, then Humphreys and Morrison carving out exceptions for independence. And now, fast forward to today, it feels like the pendulum is swinging back hard. The legal ground seems really shaky for these independent agencies now. The Supreme Court's been chipping away at Humphreys and Morrison.
That's right. This modern shift, it really started picking up steam about, say, 15 years ago. In 2010, there was Free Enterprise Fund. The court struck down a system where you had 2 layers of for-cause protection. Too much insulation from the president, they said. Then came SELA law in 2020. Big one. Chief Justice Roberts wrote that the head of the Consumer Financial Protection Bureau, the CFPB, could be fired at will by the president. He explicitly said the core holding of Myers, that unrestrictable power over purely executive officers, was still the rule. He really limited Humphrey's executor to its specific facts, basically saying it was the exception, not the rule. And just a year later, Collins v. Yellen doubled down, saying even modest restrictions on removal get in the president's way. So what you're seeing is this steady dismantling of those independence protections, centralizing power back with the president in a really significant way.
And it's not just one party pushing this, is it? You mentioned it's a cross-administration trend.
Well, yes, to some extent. President Biden, for instance, early in his term, removed the NLRB general counsel and the head of the Social Security Administration. Those actions were generally seen as consistent with these more recent Supreme Court decisions, like SELA law and Collins. So there's a broader trend towards asserting more presidential control, even if the approaches differ.
But President Trump's approach in the second term seems particularly, well, direct.
It is very direct. He's not just working within the newer precedents, he's actively challenging the older ones head-on, firing officials at places like the FTC and NLRB, despite those existing for-cause statutes still being on the books. And his supporters, like Professor Joel Alicea, argue he's simply exercising the full constitutional power the president always had. Their view is that those laws Congress passed restricting removal were unconstitutional from the start.
And the Justice Department is backing this up officially.
Yes. The DOJ has stated it won't defend these for-cause provisions anymore in court. In their legal filings, they're actually arguing that Humphrey's executor, that key 1935 case, was wrongly decided and should just be overturned completely.
Wow. So the executive branch itself is asking the Supreme Court to throw out nearly 90 years of precedent.
That's the strategy. To get a clear ruling that restores what they see as the president's original unrestricted removal power. Now, some lower courts have initially pushed back. You mentioned Judge Lauren Alicea, who temporarily reinstated the fired FTC Commissioner Rebecca Slaughter, pointing to those long-standing protections. But the administration is appealing those rulings. They want this fight to go all the way up. And remember, those stays the Supreme Court granted, allowing the firings of Wilcox and Harris to proceed. That shows the High Court is willing to let the president act while this bigger legal question gets resolved. It gives the administration immediate leverage.
There was also that amicus curiae brief you mentioned earlier, the friend of the court filing supporting the administration. That sounded pretty pointed.
It was. The brief claimed that some lower courts were showing shocking animus and issuing politically motivated injunctions. It specifically counted 54 injunctions against the administration in the first 3 months of the second term, and noted that 42 came from judges appointed by Democrats. The implication, according to the brief, was that these unelected federal judges were deliberately trying to hamstring the administration's policies.
So it's framing this as a judiciary potentially overstepping its bounds in a political fight. That raises big questions about checks and balances itself.
It really does. And this whole battle, it has potentially massive consequences for how our government actually functions. If the president gets this completely unfettered removal power, critics warn about chaos, agency instability.
Yeah.
Could an administration just, fire everyone at an agency whose mission it opposes, like the EPA or maybe the Federal Reserve? Could that lead to a de facto shutdown of key government functions? The potential for disruption is significant.
But on the flip side, there's that argument about making government responsive to the voters. That amicus brief argued that thousands of federal officials were refusing to implement the agenda voters supported, making it necessary for the president to assert this power. It frames it as democratic accountability. The elected president needs the power to make the government actually do what the people voted for.
Precisely. And proponents of this view argue that Congress, maybe aided by the courts over time, has created this sprawling Leviathan bureaucracy. They say this administrative state operates with too much independence, undermining the separation of powers intended by the founders. So, from their perspective, the president's actions aren't a power grab, but an attempt to rein in a bloated government to restore constitutional balance and make government accountable again.
This whole debate about powerful institutions and accountability, it echoes concerns we hear about other areas too, doesn't it? Like big tech. You hear people like Senator Hawley questioning not just the size of companies like Google or Amazon, but how they operate, the algorithms, the business models, their influence on, how we think and interact.
That's a really interesting parallel.
It feels like there's this broader anxiety about powerful entities, whether it's government bureaucracy or tech platforms, and who holds them accountable. How do we ensure they serve the public interest?
Absolutely. And the question is, in a world with these incredibly powerful institutions, how do we ensure accountability? How do we prevent unchecked power, whether it's an entrenched bureaucracy or a dominant corporation? These legal fights over presidential removal, they seem technical, but they're really hitting at the heart of that larger question. Who's ultimately in control, and are they accountable to the people?
So wrapping this up, what's a big takeaway here? It really feels like we've watched the legal understanding swing dramatically back towards a very strong view of presidential power.
I think that's right. It's more than just a legal adjustment. It's like a fundamental reassessment of the checks and balances we thought were settled. And these current court battles, they're likely going to force the Supreme Court into making a really definitive statement, one that could reshape the entire administrative state, either cementing presidential control or, perhaps less likely now, reinforcing agency independence. It really shows how these foundational constitutional arguments are still alive and kicking, shaping our government today.
So here's something to think about as we finish. If the president does end up with this unrestrictable power to remove virtually any executive officer, like the recent court trends suggest, what does that actually mean for the day-to-day running of the government? What happens to stability?
To expertise, to the idea of political neutrality in agencies that handle everything from environmental rules to financial regulation. Does this get us closer to what the founders envisioned, an energetic, accountable executive? Or does it push us into uncharted territory, risking too much power in one person's hands? That's the fundamental tension we're left with.